Hi there. In this video, we are basically going to be looking at the burden of proof in criminal cases. We'll also be defining what burden of proof is. We'll proceed to look at the general rule. We'll also look at the position of the law as pertains the burden of proof. Then we'll proceed to look at the exceptions governing the burden of proof. Of course, as usual, in between there, we'll be looking at one or two cases pertaining to burden of proof. Hi there, my name is Mutiawa Conrad. I'm a lawyer and a private law tutor. And before we start on our class, I encourage you to ensure that you subscribe to my channel. Also turn on the notification so that every time videos are released, this is brought to your attention. Also like and share this video with your colleagues so that they are also able to benefit. And also, students interested in private law tutorial sessions, please feel free to reach out to us. We can be able to help you. Private arrangements can always be made to ensure that we help you to improve on your grades. Our numbers are down in the description box. You can always contact us when you're ready. So let's start right away with our topic, which is burden of proof in criminal matters. And by way of definition, what you have to note is that basically when we talk about the burden of proof in criminal matters, the term burden of proof simply means the duty to prove the existence or non-existence of a fact. Okay, so the moment you have that duty to prove whether a certain fact exists or it doesn't exist, then basically that is what the burden of proof in essence means. So let's proceed to look at the general rule. Okay, so the general rule as pertains the burden of proof is that the burden actually lies on prosecution, okay, or the person who accuses the other. So prosecution has the burden in criminal matters to always prove to prove a case. Okay, so the burden always lies on them. It lies on prosecution as a general rule. Of course, later on in this video, we are going to be looking at the exceptions to that general rule. But before we proceed, let us now look at the position of the law under statute. Okay, what does the law provide? What does the law say? What are the principles governing the burden of proof under statute? So I encourage you to look at the Evidence Act, Cap 6, and the Evidence Act lays down specifically between sections 101, 102, and 103 of the Evidence Act, Cap 6. It actually lays down the principles governing burden of proof in criminal matters. Okay, so I invite you for starters to look at section 101 of the Evidence Act, which actually provides that whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he or she asserts must prove that those facts exist. So basically the section is trying to say that if you want court to rely on a certain set of facts, the burden is on you to actually show that those facts exist. So the burden to prove facts is squarely on the person who wants court to believe in those facts. Now, when a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. So if you're the person who has to prove certain facts, then in law we say that the burden lies on you. Let's now proceed to look at section 101 of the Evidence Act, that is Cap 6. And basically this section lays down the person on whom the burden lies. And basically, as earlier discussed, when you look at section 101, it provides in summary that the burden lies on prosecution. But verbatim, the section actually states that the burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. Of course, the party that would fail is prosecution, or it is the state, in case evidence is not given. That's why I was saying that the burden lies on prosecution to prove their case, of course, on a standard of beyond reasonable doubt. Then lastly, I encourage you to look at section 103 of the Evidence Act, Cap 6. And basically the section states that the burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence. Okay, so again, this section is providing that the burden is on the person who wants court or who wishes court to believe in the existence of certain particular facts. And of course, this is prosecution. It is prosecution that would want a conviction. It is prosecution that would want the evidence adduced by it to actually be taken by court. Therefore, the burden lies always on prosecution. However, this section comes in actually to introduce the legality of exceptions, and it goes on to provide that unless it is provided by any law that the proof of that fact shall lie on any particular person. So this section 103, goes on to accept or to allow what we call statutory exceptions. It goes on to allow any other exceptions, provided that the law provides for such exceptions. And if the law provides that actually the burden lies on that person, then indeed the burden shall lie on that person. So it is actually section 103 that ushers in the exceptions to the general rule, which is that actually the burden lies on prosecution. But however, before we go on to examine those exceptions, we are going to first look at an interesting case, which is actually the locus classicus on the burden of proof in criminal matters, and that is the case of Wilmington versus DPP. It's a case of 1935, SC page 462. And basically the brief facts of this case were that the defendant was charged with murder of his estranged wife, and he claimed that he had been trying to persuade her to come back to him by threatening himself, and the gun had gone off accidentally. So the gentleman was actually charged for murdering his wife, and he was saying that the gun had gone off accidentally. Now, the trial judge, when he was charged for the offense of murder, the trial judge directed the jury that once prosecution proved the fact of killing, it was for the defense to proceed and prove the absence of malice. Now, it was held by the House of Lords. The case actually was appealed up to the House of Lords, and the House of Lords actually guided and stated that that direction by the trial court was actually wrong. It was wrong to direct as such. And of interest to you, I encourage you to look at the judgment of Viscount Sankey, which actually laid down the general rule, which was that the burden actually lies on prosecution, and there is no duty on the accused person to prove their innocence or to prove that actually they are not liable. So basically that is the general rule. But also of interest in this case, the House of Lords also proceeded to state that whereas actually the burden lies on prosecution as a general rule, but the House of Lords actually recognized two exceptions, and exception number one recognized by the House of Lords is in cases of insanity. So in cases of insanity, the burden actually lies on a provisional burden lies on the accused person. Then the other set of exception is what we call statutory exceptions. As we have already seen under section 103 of the Evidence Act Cap 6, it actually states that where there is a certain statute that provides for the burden to be shifted onto another person, then the burden shall be on that person. So the House of Lords simply recognized insanity and statutory exceptions as the only exceptions to the general rule that actually the burden lies on prosecution. Now, this actually brings me to the exceptions of the general rule. But however, before we look at the exception to the general rule, it's important from the onset to note that actually what shifts is not the entire burden of proof, okay, but it is simply what in law we call the burden of rebuttal. It is a provisional burden that actually shifts to the accused person and not the entire burden to prove the case. This is very, very important to note because here students tend to actually confuse this aspect. So ladies and gentlemen, at this juncture, let's now proceed to look at the exceptions to the burden of proof. Okay, and we are going to first look at the exceptions, some of the exceptions which are provided for under statute. There are a number of exceptions, but we'll look at the most prominent and common exceptions provided for under statute. Now, the first exception is what we call the doctrine of recent possession. Now, basically, the doctrine of recent possession, this is it is a criminal doctrine which actually presumes that a person, it is actually a doctrine of circumstantial evidence, okay? It is a doctrine of circumstantial evidence, and it refers to a situation where a person is found in possession of goods recently stolen. Now, the law presumes that a person found in possession of recently stolen goods is either the thief himself or herself, or received such goods knowing them to be stolen. And as such, this doctrine will take it that actually that person is the thief themselves. Now, unless that person can give an account or explain, give some sort of explanation as to why such stolen goods are in their possession, if they don't give any reasonable explanation or some sort of explanation, then definitely it will be taken that such persons have stolen such goods, and of course a conviction shall be entered. This is very important to note. But provided such a person who has been found in possession of such stolen goods is able to give a certain account or some sort of explanation, then of course the burden then will go back to prosecution. Please note here, with the doctrine of recent possession, the burden, the provisional burden simply shifts to the accused person to give some sort of reasonable explanation as to why they are in possession of such goods. If they give some sort of explanation, okay, then the burden will go back. The overall burden goes back to prosecution, then to discredit such a type of explanation. Okay, let me give us an example. Assuming that Justin has been, let's assume, let's say Peter, okay, assuming Peter has been found with stolen goods, okay. If Peter has these stolen goods, okay, it brings on Peter a provisional burden, because you see, the doctrine of recent possession will presume that actually Peter, who has been found with these stolen goods, it could be, for example, a phone, is actually liable. He is the thief. That is what the doctrine will presume. However, it is now on Peter to show, okay, or to give some sort of reasonable explanation or an explanation to actually show that, look, whereas you have found me with this stolen phone, actually the burden, actually this phone maybe was left at my office or at my home by a certain friend of mine. This is not my phone. So the moment they give some sort of account, then the overall burden will go back to prosecution to show that actually there is none of Peter's friends that actually left the phone at his place. This phone is in his possession, and there is no reasonable explanation. If that is done by prosecution, then they would have, of course, churned out the burden that is on them. Now, I encourage you to go and look at section 314 of the Penal Code Act Cap 120. This section actually provides for the offense of receiving stolen property. So in case you're found with stolen property, the doctrine of recent possession is thrown into motion, okay, and it will be presumed that actually you are the thief who has been found in possession of those goods, and the provisional burden is shifted on you to give some sort of explanation. And when you give that explanation, the burden then shifts back to prosecution to prove this case, or to prove or to adduce evidence to discredit that explanation by you. The second exception is what we call false checks. Now, it is a common scenario that someone could issue you a false check. Let's assume someone has your debt, you go to them, they then write you a check telling you to go and withdraw money on a certain account. They purport to be paying you to go and withdraw that money. Now, in case you proceed to withdraw that money and actually you find that there is no money on such an account, such person that would have issued that check can be charged for the offense of issuing a false check. Now, one, it's important to note that the law actually provides for the offense of issuing a false check. I encourage you to look at section 385, subsection 1 of the Penal Code Act Cap 120, which actually provides for the offense of issuing a false check. Now, to the person who has issued a false check, the burden is on them. A provisional burden, the burden partly shifts to them to show that actually at the time they issued the check, they did not know that such an account actually didn't have money. Okay, so the provisional burden shifts to them to give some sort of reasonable explanation, or to give an account to actually prove that they did not know, it was not within their knowledge, that at the time they issued the check, the account did not have money. And of course, the moment they do that, the burden now shifts back to prosecution to actually show that these people knew at the time of issuing the check that actually the account did not have money. Let's now proceed to look at another statutory exception, and that is under Section 2 of the Anti-Corruption Act of 2009. Now, Section 2 presumes any gratification by a public servant from a person who has dealings with a public body to be corruptly received, unless the contrary, of course, is proved. So the burden to rebut the presumption under that section is that the gratification was not an inducement or reward, would be on the accused. So basically here what we're trying to say is that the law presumes that in case you receive any gratification by a public servant from a person who has dealings with a public body, and that such gratifications have been corruptly received, of course, unless the contrary is proved. Very, very important. And of course, if you prove if you give an account or reasonable explanation, as we said earlier, the overall burden then now shifts back to prosecution. The other statutory exception under the law is actually under the offense of illicit enrichment, and it is under Section 31, subsection 1B of the Anti-Corruption Act of 2009. Basically, that section presumes the possession of pecuniary resources or property disappropriate or not equal to the accused's income or personal sources to have been obtained corruptly, unless he or she satisfactorily accounts for that possession. Now, the burden is on the accused. How he or he came into possession of the property if it wasn't corruptly obtained. So, the moment you're charged for the offense of illicit enrichment, a partial burden shifts on you, okay, to show that actually, to show how you actually obtained such extreme wealth, which is not equal to the amount of salary that you're earning. The moment you give some sort of reasonable explanation, then the burden goes back to the prosecution overall to prove the ingredients, and also, of course, to adduce evidence to show that actually the same was received unlawfully. Let's now proceed to, those are basically the statutory exceptions, okay, which are provided for under the law. Let's now proceed to look at another exception which is under defenses, and that is the defense of insanity. So we have looked, there are a number of videos on this channel, and I encourage you to go and look at them, in which I have actually attempted to define this defense of insanity in material detail. But however, it's important to note that under the law, specifically Section 10 of the Penal Code Act, it presumes every person at any material time, any person who is walking, to actually be sane. Okay, we assume, the law assumes that any person walking on the street or going about their duties is sane. They are normal, they are right-thinking members of society. However, if you are charged for an offense, we presume that you are mentally okay. Of course, until the contrary is proved. And I encourage you to look at Section 10, okay? And it's also important to note that insanity is a defense to the commission of an offense, but the burden is on the accused to show that he or she was insane when he or she committed the offense. So the burden is on them to prove that actually at the material time of the commission of the offense, they were actually suffering from a disease of the mind and they were insane. And that is under Section 11. Okay, look at Section 11 of the Penal Code Act. Also of interest is, I encourage you to look at the case of Bratty versus Attorney General of Northern Ireland. It's a case of 1963, reported in SC page 383. It's a House of Lords decision, and of specific importance, I encourage you to look at the judgment of Lord Denning, who actually stated that as so far as the defense of insanity is concerned, the defense must prove that the act was involuntary due to the disease of the mind. So as pertains the defense of insanity, according to Lord Denning, he was stating that the moment you raise this defense of insanity, the burden, a provisional burden, now shifts on the defense, okay, or on the accused person to actually adduce some sort of evidence to show that actually they were insane. they were operating under the disease of the mind. Because remember, we already saw under Section 10 of the Penal Code Act Cap 120 that actually the law presumes any working human being on this face of planet to be sane, to be mentally stable. So if you're saying that you committed the offense in a state of insanity, then a provisional burden shifts on you to prove that insanity. Let's now proceed to look at the defense of alibi. Okay, so basically the defense of alibi, this is a defense that is raised by a party who is basically saying that at the material time of the commission of the offense, I was actually not at the scene of crime. I was absent, I was in a totally another location, and therefore it couldn't happen that I actually committed that offense. Now, the moment you raise such a defense of alibi, a provisional burden shifts onto you to actually adduce or give some sort of account to show where at that material time you were. Now, the moment you give that account or adduce some sort of evidence to show that at the material time you are actually somewhere else, that is all you actually do. The moment you do that, the overall burden now shifts back on prosecution to actually put you at the scene of crime. Prosecution must adduce evidence, okay? Cogent, strong evidence, watertight evidence to actually show that you were at the scene of crime at the time the offense was actually committed. I encourage you to look at a very interesting case of Wavamuno Kamya versus Uganda. It's criminal appeal number 16 of 2000. It's a very interesting case. Please go and read that case. It will help explain and show the defense of alibi at play. Let's now proceed to look at another exception, and that is the exception of provocation. The law that actually provides for this defense, I encourage you to look at section 193, subsection 1 of the Penal Code Act Cap 120. It provides for this defense. There are also classes on this channel. I encourage you to search my channel and find the classes that actually look at the defense of provocation, the defense of alibi, and also the defense of intoxication, which I have discussed on this channel previously in material detail. However, for purposes of this class, as I have already stated, provocation is also another exception to the general rule. And basically, here provocation, the defense of provocation applies to a person who has committed a crime, but however, they committed that crime after being provoked by the complainant, okay? And their argument before court is, look, I acted at the material time out of the heat of, I acted in the heat of passion, and of course, at the material time, I was deprived of the power of self-control, okay? So, if you raise the defense of provocation, a provisional burden is on you to show that actually you acted in the heat of passion and that at the material time, the words that were stated by the accused person, the words that were stated by the complainant actually deprived you of the power of self-control. They are words they stated or actions that they did that deprived you of the power of self-control, that you acted in the heat of passion at that material moment without allowing yourself the time to cool. So it is you to give an account of the same. And the moment you do so, then the overall burden goes back to prosecution to prove otherwise. Lastly is the defense of intoxication. The defense of intoxication is provided for under Section 12, subsection 2, A and B of the Penal Code Act, Cap 120. So the defense of intoxication basically applies to a party who has committed a crime, but at the material time of committing the crime, they were actually intoxicated. Now, the intoxication could be maybe because of a drink or because of certain substances or chemicals that have been added to the drink that someone was actually taking. It's important to note, as I have already discussed this offense on this channel, please I encourage you to go and look at this defense in material detail after watching this video. It's important to note that the defense of intoxication does not apply to a person who has actually self-intoxicated. If, for example, you go enter a bar, you take bottles of beer, making yourself drunk or tipsy, and then you proceed to commit a crime, the defense of intoxication will not apply to you. This defense only applies to a party who has been intoxicated by an action of a second party, not known to them. Assuming you're in a bar taking, let's say, a drink, let's say water or soda. However, another party comes in to administer certain substance in your drink, which then makes you lose your proper state of mind, leading you to commit a crime. Then such a person can actually raise the defense of intoxication. But a person who has intoxicated themselves cannot succeed to raise this defense. Also important to note, you have to prove that actually the intoxication was administered without your consent by a malicious act of another party. And also secondly, it made you, who is the accused person, temporarily insane as not to know what had happened, or that if you knew, you actually didn't know that the same was wrong. Of course, that means your actions were not wrong. Now, if you show this, then the overall burden of proof will then shift back to prosecution to actually prove their case. The burden then will lie on prosecution. Ladies and gentlemen, that's all basically on the burden of proof and the exceptions. I encourage you once again to subscribe to my channel if you haven't. Also turn on the notification, like and share this video with your colleagues so that they are able to benefit. Students interested in private law tutorial sessions, in case you need to improve your grades, please contact us. Our numbers are down in the description box. We only have limited slots because we can take on only a few students at a time. Thank you very much for listening in, and we meet in another class. Bye-bye.